because it's unusual that we get your presence. And
That's not
it's
true.
exciting for us because typically, there's so many different types of mediation. And really, our responsibility as leaders for Second Saturday is to present different types. And it's really an honor to have the Honorable Lorraine Norland here today to explain the different types or the type of mediation that you practice. And we're really excited about that. So thank you for letting us record this today. Just so you know, we are welcoming here the Honorable Lorraine Norland, and she will be speaking on mediation. Judge Norland has sat on the bench for over 20 years in Fairfax County and now brings her legal expertise to help people through mediation. And her contact info is on the agenda, and you can connect directly with Judge Norland at her firm, AIM Independent Mediation. And like I said, we're super excited to have you here today. There's not many, and during our normal Second Saturday, we only offer mediators to come in that are also family law attorneys, but just know that not every mediator out there is a family law attorney. So when you are doing your research, please do it thoroughly so that you know who you are hiring in this process, because at the end of the day, the goal is to get a well-documented, well-written settlement agreement, because you're going to be using this agreement for the rest of your life. So with that, I will turn it over to you.
All right. Well, thank you very much, Alice. Geez, I'm embarrassed by that. But, so for those of you who may not know me, if you look up my website, that would tell you basically what I've done since graduating from law school back in 1980. I was a prosecutor, and then I was a private attorney for about 11 years, and then went on the district court. And then from there, I went to the circuit court. The circuit court does just about everything, but about 50% of what we do is domestic litigation. And so I would have to say that very quickly you become very educated in the areas that you may not already know. Although I would say a good portion of my practice was domestic when I was in private practice. So what's the difference? I mean, what kinds of mediations would you be looking at? So one of the types of mediations that you would potentially do is called collaborative law. I'm not that familiar with collaborative law, but it's just what it talks about. It's like the parties are collaborating. And it's different, and it's something to look into, obviously. But the other type of similar mediation is one with an attorney. So there are lots of family law attorneys who do mediations, and they will mediate these types of disputes. And they'll also mediate where one party is unrepresented. We call them pro se's because they're for themselves in Latin. So a judge, however, a retired judge, is not going to do pro se mediations. And there are a couple of reasons for that. Number one is the Supreme Court. When you get certified, the Supreme Court says, do not do that as a judge, because let's say one side's represented and the other side is not. The side that is unrepresented, no matter how many times you tell them, I'm not representing you, I'm not giving you legal advice, they're going to view it as the judge representing their side and giving them legal advice. And it's just human nature. We understand that. The problem is that you can say ABC to a person who is not familiar with legal terminology, and they hear DEF. And so as a result, the judge can say no. Like, let's say the person gets upset because most folks end up with a little bit of buyer's remorse after they've signed these agreements, and they start second guessing. And that also is human nature. They may have family members who are saying, what did you agree to? And those family members have no idea how the process went. They have no idea how that portion was agreed to. And so as a result, when that sort of buyer's remorse sets in, who are they going to blame? Who is the person who's unrepresented going to blame? They're going to blame the judge. A person who is represented will blame their attorney. And then So the attorney's going to have to defend whatever happened. But if you have a pro se, they're going to get angry with the judge. They're going to try and file suit against the judge. Well, that creates a whole nightmare for the judge and for the court, because how is a court going to possibly hear a case involving a judge? So then the Supreme Court has to get involved, and they have to send a special judge to hear it. It's such a nightmare that the Supreme Court has said, if you do that, we wash our hands of you. So, of course, no judge will do a mediation where either one of the parties is pro se. So, first of all, you got to understand that. Second of all, a retired judge will do a different kind of mediation. So most of the mediations involving attorneys are what they call facilitators. So they're facilitating discussion. So what do you think about that? So what did you hear that person say? And how would you respond to that? And what would you like to say in response? And it's a little bit like a counseling session, but at the same time, at the end of it, whatever agreement you come up with, the parties are told that they must go seek the advice of counsel to make sure that the agreement is appropriate. And then a lot of times they don't do that. So, but when you are dealing with a judge mediator is going to have two attorneys there, and the judge is going to be instructing the attorneys to be drawing up the agreement. And most agreements contain about 2/3 boilerplates, that is standard provisions. And the rest of them are the specific provisions to this particular case. So we as judges will instruct the attorneys to draw up a boilerplate provision or a boilerplate agreement that we can begin to insert the various provisions as they are agreed to, so that we're working on an agreement as we're going through the entire mediation. And a mediation with an attorney will probably take, mediations where you have an attorney mediator can take course over a number of different sessions. Whereas if you have a judge mediator is going to do that mediation most likely in one session. And that can go for 12 hours, it can go for 14 hours. And it's just, the intent is you get this agreement done. Even if you don't get agreement on all the issues, you're going to get agreements on some of the issues. So you will try to your best to get an agreement. It's the whole situation, but oftentimes it's just a portion of it. But regardless, the goal is everybody walks away with a written agreement. And the other thing is that because an attorney who's doing mediation is doing facilitative, a judge, because of their unique situation, gets to be a little bit more evaluative. That is, they can evaluate the case. So I start off with and all judges really start off with a joint session where they explain what mediation is about, the benefits of it, and then the process. And then once that's done, we break out into individual sessions, individual caucuses, so that we can have confidential discussions. And during those confidential discussions, we're talking about things that are unique to that side of the case. I will say, so what's your dream outcome? What if you had a dream outcome? What would it be? And then I would say, what do you think are the problems with that? So the judge gets to evaluate. The judge can say, well, I hear what you're saying, but based upon my experience, if you were to go to court, I'm thinking that this would be a likely result. And so you evaluate the strength of somebody's case or somebody's point or somebody's issue. And so you get that evaluative session instead of just facilitating discussions. And so as a result, you really get an insight into how the case could end up or take place when you get to court. And I've always thought that was just so incredibly helpful. When you decide you're going to go to court and you're going to go to trial, you are not paying attention to the other side. You're not paying attention to the other perspectives or anything else of that nature. That can be incredibly expensive. Plus, on top of that, when you are going to go to trial in a divorce case, the greatest expense usually happens in the last 2 weeks, because it is the most intense time for discovery. And so one of the questions that was asked earlier was, how do you determine whether or not somebody's got reasonable expenses for their business or whether they're understating their income, that sort of thing. And what happens is that in order to properly evaluate, one of the ways that you can evaluate that as an attorney for a client is you go through all of the credit card expenses and you are looking at each and every expense. And then you're comparing that with those types of expenses in previous years. And you're trying to see whether or not they are using it for personal things. So let's say they only earn $30,000, but they're spending $90,000 on personal things. So now you know that they aren't really earning $30,000. They're actually earning closer to $90,000. And that's part of the whole process. But imagine how expensive it is to pay for an attorney or even their paralegal to go through each and every credit card and each and every charge, and then determine whether or not it's appropriate in light of charges and credit card expenses in previous years. And that can be just immensely expensive. So, and that usually happens in the last few weeks before trial because attorneys are trying to avoid those expenses. So what you want to do is you want to do a mediation, either with an attorney or with a judge. And before the big, huge hit of expenses comes on. And when you do, what you're going to get is you've got a pretty good idea at that point how your case is going to go, what your arguments are going to be, what the other side's arguments are going to be, and you can ask the judge, so what do you think would happen? What do you think is going to happen? I'm going to make this argument, or they say, this is my position on this. And I, as a judge, can say to them, well, one of the things you need to understand is that when you are in front of a judge is going to be required to follow the law and only the law. And the judge is also going to be required to be pretty quiet because anything that judge says is on the record. And anything that's on the record is subject to appeal. Now, it used to be that you had to have some sort of grounds for that appeal, but now they've opened it up and every single case has an appeal of right. So every single case can be appealed. And if you think a trial is expensive, you wait till you go through the expense of an appeal. And that's the other thing about a mediated agreement is that it's a contract. And so it's not like you can appeal it to the court or you can appeal it to the Court of Appeals unless some grievous error has occurred. But that's not likely because it's a contract and you've entered into that contract. So you avoid the expense of trial, but you also avoid the expense of an appeal because if folks are that certain about their position that they want to go to court, they're most likely also going to appeal if they didn't get what they wanted. So it's become much more expensive to go to trial. The other thing is that I tell people, so a judge is sitting there and they're really not saying what's going on in their head. You may think that you're making a wonderful impression on a judge, but a judge is not going to relay that. And the judge I know plenty of judges who just sit there and smile and nod, even though they're thinking, this person is lying to me. This person is lying to me. And you think you are, or the other side or whoever it is thinks, oh, I'm making this great impression on the judge because the judge is smiling and nodding. And instead, you're making the absolute opposite impression because the judge isn't saying it out loud. The judge really can't say those things out loud. And then the judge is going to issue a decision. And many times people just sit there in shock. They have no idea. How did they reach that decision after my evidence? How did they reach that? And the judge really can't go into great depth as to how they reached that decision. So you're sitting there in the dark trying to guess why it is that the decision came out the way it did. The other thing that's important about mediation, well, in mediation, the judge who's hearing it or mediating with you is going to say, well, here's what I would think if you said that. And here's how I would react if you said that. And here's what probably would be the likelihood or the outcome that would happen if you said those things or you presented that issue or if they presented that issue. So you really get insight into a judge's thinking. And we all do think pretty similarly after a while, because we're bound by the law. And we have to follow the law, and we have to give a decision that follows the law. It's very, very narrow. It used to be wide. Everybody thought, well, it's domestic. It's equitable. It's the wild, wild west, but it's no longer that. Everything, as we started to get diverse decisions from court to court, from district to district, the legislature started bringing it in narrowly, so that judges have to walk a very narrow path, and their decision has to walk a very narrow path. And when they're giving that decision, they have to say, I'm deciding on this element, this factor, this factor, this factor. And they really don't get into great detail on each factor. They just say, I'm considering this factor, and here's what I've decided. In mediation, we talk about those factors, but we also talk about how a judge is likely to view those factors and apply those factors to a particular case. Another thing that's important is that everybody comes into court, and I usually use this analogy, with a box full of items, of facts, of statements made by people, of various things that they are convinced are extremely important to the judge making the right decision. The problem is that the law is so restrictive on what can come in and what can't. So for example, you want to bring in a statement that your child said to you, or you want to bring in a statement that that somebody said to somebody else, or your husband said to somebody else, or your wife said to somebody else. There's no guarantee that those statements are going to come in. There really isn't, because there's so many laws that restrict that. And so because it's so restrictive, you come in with this box full of items that you are convinced a judge has to hear or consider in order to properly make a decision, in order to really know what's happening. And that judge might hear only 10% of that. So you're walking out saying, okay, I just had a stranger decide my future. And that stranger only heard 10% of what I think that stranger needed to know. And that stranger didn't even explain to me why they made that decision. That's really what happens when you get to court. And it's expensive. I have yet to see somebody go to court and be really, truly happy with what happened yet. And yet, when I go into a mediation, I've got people hugging me at the end. I have people writing me letters thanking me. They're so grateful over the fact that they really got an insight into how a court views a divorce case, how a court views custody issues. They got real insight into how a decision is made and what a judge can and cannot do. And they also have the ability to sort of take that box and dump it out on the table and have a judge go through it with them and say, no, that can't be considered, that can't be considered. Yeah, okay, this is important, but let me tell you how a judge is going to view it. And they're usually shocked, but they are so appreciative of the fact that they learned this before going into court and risking it all. And so as a result, they are able to make a much more knowledgeable decision about reaching an agreement, a much more knowledgeable decision about making an agreement between themselves as to how they want to live their lives and how they want to raise their kids and how they want to divide the money and how are they going to go forward. One of the things that I was listening to earlier was college expenses. So when you get to court, a judge can't order college expenses. They can't. But in a mediated agreement, that's one of the things you can talk about, because in a mediated agreement, that's a contract, and you can put things in there that a judge can't do because the law doesn't allow them to do it. And that doesn't mean that what's in an agreement is illegal. It's just that there are certain provisions that are included that would not necessarily be able to be addressed by a court. And they're perfectly legal agreements, but it's just not something that a court is allowed by law to provide for in a final decree. And college expenses is probably the closest, the clearest example I can give. I also heard about discovery issues and what you should do. One of the things that I would tell every client was, if they had not yet broached the subject with their spouse, and even if they had, I would say, get home immediately and make copies of everything. Make copies of everything. Just put it in a box and make copies. And then you've got all your copies. And then you're not in the situation where you're having to beg the other side for copies. And that's expensive, getting those things. If your name isn't on an account, it's expensive. Find out what the finances are, what the financial structure is. Even if you haven't said, hey, I want a divorce, you find out what it is. You have a discussion and you find out what is the status of our financial situation. If you're going to be talking to an attorney, get an income and expense sheet from that attorney and start filling it out. And you will see how little you know about your own finances and your own financial need, but it'll get you thinking about it. And so you'll be better prepared when you go for your pendente lite. So that's the first hearing about support issues. And one of the things that was also said is that there's no formula for spousal support. Well, in pendente lite, which means pending litigation. So you have a hearing before the actual trial, where a judge is deciding what kind of support things are going to be put in place, what kinds of holds on assets are going to take place, what kind of attorney's fees are going to be paid out by one to the other. So a lot of things are decided at a pendente lite. And one of the things that is absolutely necessary is a proper income and expense sheet. I rarely, if ever, saw an income and expense sheet that led me to believe that it was accurate. But when I did see it, it made a huge impact on me. And I was much more likely to award what was being asked for because it was accurate and I had little reason to suspect that it was being overblown. And so for these reasons, I could rely upon it in making a decision. So get one ahead of time and start working on it if this is really what you want to do. Another thing I just want to comment on earlier about the counseling. I used to tell people all the time, you're going to be obsessed. And when you're in a divorce situation, you're going to be obsessed with this. It's going to consume your ever waking thought. It's going to consume your dreams. You're going to eat, sleep, and drink and dream about this divorce because it's going to affect the rest of your life. And that's natural for you to be that way. And you're also going to want to talk about it with your friends constantly, ad nauseum. And what's going to happen is that you're going to drive your friends away. You're going to drive your family away. So maintain your relationships about by talking about other things. Certainly you can talk about the divorce, but try not to make it the only subject you talk about. And you're going to feel like I have to talk to somebody or I'm going to explode. So counseling is really a good option. It's an excellent option. I always recommended that. And I would also tell my clients, you're going to want to talk to me and you're going to demand so much of my time. And then when the case is over, I'm going to have to go on to my next client and I'm not going to be there for you. And you're going to feel like you're deserted and you don't have that friend that you've been relying upon all this time. I would say you have to maintain your friendships. You have to maintain your family relationships. It's healthier to do so. And counseling is always an excellent thing to do as well. So I just wanted to comment on those things that I heard earlier. But as far as mediation is concerned, mediation is an opportunity for you to see how a trial might happen, what could happen during a trial. And so it's, I think, and I believe personally, it's the best way to go. Absolutely the best way to go, because you're not taking that incredible chance when you get to court. That's so expensive to do. You have an opportunity to really pull your case together, get a better picture of your case. And even if mediation doesn't work out, you're still on a better road to possibly resolving some parts. Because as a judge, I always appreciated when people would come to court and instead of having all 15 or 20 issues, they would say, we've resolved 10 of these issues or 8 of these issues, and we only have these issues remaining. That would tell me that these people were very serious about having a meaningful resolution of their case, rather than just, we won't agree on anything. We're not going to agree on anything, and we want somebody else to decide our lives for us. That was such a negative impression that I would get from people who refuse to decide anything or even agree on anything. I understood that in some cases that was impossible because it's different from case to case. But the vast majority of cases in divorces, you've got two good people that just something bad happened to their relationship, and as a result, as I say, you've got two good people, and these good people, certainly if they have custody issues or children involved, these people know their kids. They know their kids better than any judge is going to. And as parents, they need to be able to sit down and decide, how are we going to deal with our kids going forward? Not, what does a stranger think we ought to do with our kids? I've never understood that. And as I began to realize that as a stranger, it was very, very difficult for me to make a decision that people were going to be happy with. And I hated the fact that people were walking out of the back of my courtroom and just hating every part of what they just went through. I didn't like it. It didn't make me feel good. And that's one of the reasons why when I retired, I said, okay, I'm going to do mediation. And mediation has been my opportunity to help people resolve their own issues for themselves, but do it with a knowledge that they would not otherwise have. And one of the other things that I try to do is, a lot of times as you're going through this process, you begin to doubt your attorney. You begin to question what your attorney is saying, because your attorney is saying, hey, this is going to happen and this is going to happen. And you're just like, there's no way that's going to happen. But your attorney's giving you good advice. So it's an opportunity for the judge to tell you, yes, your attorney's giving you good advice so that you can stop that paranoia. Because honestly, it's not just obsession that occurs when you're going through a divorce. It's paranoia about every single area of your life. Every single area. I tell people that going through a divorce is like insanity. And it's painful to see people going through it. Another thing that I tell people is that before you resolve your case, you're two people at war, and you cannot possibly let down your defenses to be kind to the other person or understanding of the other person. And that's incredibly painful for your children, incredibly painful for your children. And the tendency is to want to say to your children, well, so-and-so is happening, and you can't go to that private school because he won't pay for it. And you get your children in a situation where they feel as if they have to defend you, or they are what we call being parentified. So now these children are having to parent and soothe their parents' feelings. Kids need to be kids. They should never be expected to be adults. And so I tell people all the time, just do not involve your kids in any way whatsoever. And if you need to go to counseling because the other side is doing that consistently, well, then go to a counselor, because it's so painful for children when you do that. I think that's really all I have to say. So I would be glad to take any questions.
Yeah. First of all, I'm glued to the computer like I'm watching TV. I really just, I hope everyone listening, I feel like they feel like me. I really just appreciate your candidness. And this has been great. I don't see any specific questions. They're more, for the attorney at the end, but I have a couple of questions, and then people maybe will kind of spin some in here. But I talk to people all the time, weekly, and often, we're huge fans of mediation from a financial standpoint because we know it's the least expensive way typically to get divorced. And, we want to see people have financial independence, beyond divorce. So that's a big piece of it, but also just, and you addressed it, the emotional piece of it and the ability to be creative in your agreement. But how does somebody, I talk to people and they say, well, he'll never agree to mediation. Like, what do you think is the best way someone can really, broach a subject with a spouse that they're not having maybe the best communication with, and how they can bring them to mediation?
Well, that's really something that if a spouse is reticent to do that and fighting it, it's usually a control issue or a trust issue. So they need to have that addressed to them by their attorney. Their attorney is the best one to do that. And so if that's the case, then your attorney needs to address that with the other attorney and say, let's do this. There are some attorneys who would rather fight the case than resolve the case for a variety of reasons. I've never really personally understood that. I remember one time I was being interviewed for a firm that I was going to, and they asked me, so how come we almost never see you in court? And I'm like, well, because I'm practicing domestic relations appropriately. I'm not going to court every single time and having to bill my clients. I like to keep my clients' bills lower. But everybody has their different styles. That was just mine. And the thing that people need to understand is that judges talk. And when they come off the bench and they're going back in the back and they're talking with other judges. And as a result, there really is sort of a consistency among a particular bench as to how things are viewed, because we know what's going on. We see what's going on, not just in our own courtroom, but we hear what's going on in other courtrooms. So we're very much aware of newer issues. We're very aware of newer arguments. We see some of the abuses that are going on. One of the questions I saw come up was about emotional abuse and what sort of effect that has. And I would like to say just two things about that. First of all, people think that adultery is something that a judge is going to punish the other side for. It's not really true, because marriage these days is viewed, a marital relationship these days is viewed more as a business, and it's treated as a business dissolution for the most part when it comes to finances. A court is never going to punish a parent for cheating by taking away custody or visitation. They're just not going to do that. And because regardless of personal choices that a person may make, however inappropriate they may be, there's both, the children are entitled to both parents. And so that's the court's view. As far as the cheating or adultery is concerned by the cheater, unless that cheating has significantly impacted the finances of the party, such as going out and buying a condo for a lover or something like that. So unless there's a significant impact on the finances of the parties, adultery is really not going to have an impact on the ultimate division. And if a court does decide that they're going to do it, they're not going to say it out loud. They, instead of doing a 50-50 division, they might do a 55-45 division, but they aren't going to say it's because of the adultery. They're going to pin it on something else. But that's might be what's going through their heads. And that's why I say that you're not going to hear a lot of the reasons stated in court. But if you were in mediation, a judge could say, well, yeah, I mean, that's horrible what happened and the way it happened. And so it's going to impact how the judge is going to decide the case in all likelihood, but they aren't going to be saying it out loud. So you will never know. The other thing that I tell people when it comes to emotional abuse is it has to be severe for it to really have a true impact. And one of the things that I say in every single mediation is I give an illustration of perception. And that is this. So imagine you're in an auditorium, and you're in an auditorium in a college. So it's like a big auditorium, the professor's at the front at the podium, and all of a sudden the back door flies open and a streaker runs through the auditorium, runs through to the professor and goes behind the professor and goes through a door that the professor's left open. And so everybody's in an uproar in the classroom. And the professor says, everybody settle down, take out a piece of paper and a pen. I want you to write down immediately what you just saw. And on that paper, I want you to put whether you're a man or a woman. I want you to tell me whether you're at the back of the room or the front of the room, and if you're on the right side of the room or the left side of the room. They all witness the same event. They all experience the same event, but they all saw something different because they all had a different perception. So we as judges go through training and we're taught about perception. And we're taught that just because two people say two different things doesn't mean that either one is lying. It's that they have different perceptions. So we're taught to try and see those different perceptions. And that's another thing that mediation can do, is to sort of make the other side see, help the other side see the different perceptions. So I had a mediation where this man was just saying, you know, I can't believe she's just so vindictive about my cheating, and I can't believe this. And I said, all right, well, so let's turn it around. So imagine you are going to, your wife is going off and going to these conferences and having relations with all these people at these conferences, and then hiring somebody in the office and having a relationship with that person. And everybody in the office knows what's going on except for you, until one day somebody in the office tells you. How are you going to feel? Are you ever going to trust your wife again? Are you going to want to have healthy marital relations with your wife? Are you going to even be capable of doing that? And he looked at me and he said, no. I said, that's the level of betrayal. That's the level of betrayal that you have inflicted on this woman. And you need to understand that. She may never get over that. And he was just like, I hadn't thought of it that way. I just couldn't believe he hadn't thought of it that way, but he was thinking of it from his own perception of, well, you know, hey, you know, she needs to just forgive me. I want to get back together. I don't want to lose my kids. And so that's another thing that a judge gets to do in mediation, and an attorney also gets to do in mediation, that that you never get in a courtroom, because a judge can never say that in a